My lord, in item number 21, I have filed one IA, my lord, for withdrawal of the amount, but it is not here in this, my lord. So it may be called for, my lord, today.
No, 21, I is here. Item number 45,
IA 21.
21, the IA has been listed, item number 45. The IA has been listed.
IA has not been listed. Listed, Vijay?
Please see the clause, this item number 45.
But just a minute, my lord, that is why I've seen me.
May I please, Your Lordship? Your Lordship,
Yes.
back to my Lordship, I beg to mention item number 41. I have already filed on a recent affidavit that have not taken out. This honorable court will be directed to take up the matter.
How will call it?
May I please, Your Lordship? Your Lordship, I beg to mention item number 13, Your Lordship.
Item
13, 1-3.
one.
Your Lordship, for some personal difficulties, Your Lordship, 1 week maybe.
That's right. For Miss
IH,
sir.
IH, Lordship.
IAS Lustor, learned counsel for the accused. The SSL is the matter after
1 week.
1 week.
Highly.
This matter relates to release of the amount liquidated by the insurance company.
Elect number.
Let the matter released on 28.
Oh, the number is different, my lord. That IA number is 532, my lord. Here IA number, my lord, is the 2903 for withdrawal of the amount, my lord. That's
Call it.
Please, madam. Madam, I pray for listing upon MSc appeal, madam. It was last listed in 2024, thereafter not listed for orders, madam.
When do you want?
In next week, and it next
Okay.
week.
On 4th April.
I have a similar MSc appeal not listed in, madam.
May I please, Your Lordship?
On 4th April.
Prayers for
Deeply
listing of RFA civil. May be placed on next week for orders.
On?
Next week for orders.
Lordship, with the consent of opposite counsel, I beg to mention item number 25. We
Item 35.
25.
35.
We need to file affidavit in reply, so therefore 2 weeks time will be given.
You are for the
Petitioner.
I'm for the respondent. ma'am. I'm for the respondent.
respondent. You are for the petitioner. Miss, your good name, please.
S. Sahi.
Learned counsel for the petitioner with consent from the other side plus for listing the matter after
2 weeks.
2 weeks. There.
Lordship, with the consent of other side, I beg to mention item 12. for
Item?
adjournment.
Item
Item 12.
12.
Lordship, in this case, I am appealing for the respondent, Lordship. Can it be fixed on 3rd of April, Lordship? Urgency on our stage operating, Lordship, there of 3rd of April. Yes.
Okay.
An
It's
interim
agreed
order,
by learned advocates about the parties. Resolution is the matter on 3rd of April.
Lordship, interim order.
Okay. Interim order passed earlier shall continue.
Obliged.
Yes.
May I please, my lord, I beg to mention for listing of one testamentary appeal, my lord, for orders, my lord. We have filed an IA for stay of the execution of the decree, my lord. Can it
What?
be on the next week, my lord? Delivery. 9th, a little earlier. Probably.
May it please your lordship. Item number 42, your lordship, yesterday allowed my mention for day after tomorrow, but it has wrong.
So we'll take it up day after tomorrow.
Any date, lordship.
Not
I'm
today.
ready today also or tomorrow also, lordship.
Pardon?
Tomorrow also, today itself also I am ready, lordship. If your lordship take it up today,
No,
Then
no,
I'm
we
ready.
have allowed to
Lordship,
be
I
listed
have-
on tomorrow.
yes, lordship, we have seen
Ah.
that, lordship. So matter may be directed to be listed tomorrow, lordship.
Okay.
Otherwise, it will not be listed,
Resolution is the matter as per mentioned memo.
lordship. I'm deeply obliged.
My lord, payment has yet to be released, my lord. This is not yet released, my lord.
Pardon?
Payment has yet been released, my lord.
Acha.
It is not released, my lord. So what is the reason, my learned can?
Sanction has been already been accorded, Lordship.
Mm.
I have received a letter, but
Mm.
money is not yet to be released, Lord,
Why?
by the deputy commissioner.
Why?
Lordship,
No, whether he has received the sum or not.
sanction letter has received by the deputy commissioner, but
Mm.
why
Whether he has received the fund or not.
why the required money yet to be released? Lordship, I don't know. It has been
No, he was
need to-
supposed to obtain instruction of why the
Lordship,
amount has not been
This,
released till
this
date.
letter has forwarded to us, Lordship.
When?
Lordship, maybe fix it to Lordship, so that
Yes.
I can.
You directly contact the deputy commissioner why the amount could not be released
Lords,
at 2 p.m.
Lords. Online.
Item two.
Please. My lord, we are challenging an order of the Labour Court, my lord, passed under the Trade Unions Act. I've just been informed your lordship had dealt with a connected issue, my lord. My lord, what has happened here, the petitioner is a registered trade union, my lord. Now, registration certificate was granted, my lord. Then we say, my lord, according to us, a rival organization for their own rivalry, they filed complaints before the registrar of trade union alleging that we had played fraud, we had obtained it by some fraudulent means. And the registrar of trade union cancelled the registration by an order dated 38/23. Cancelled the registration of the trade union. As per the Trade Unions Act, there is an appeal against that order. Accordingly, we approached the appellate court, which is the Labour Court. Now, Labour Court initially granted stay, my lord. These proceedings were pending. And against an order, we had approached this court on an earlier occasion also. Now, this court in that particular order specifically observed that this power to cancel is only if there is a fraud, and it cannot be exercised at the behest of complaints from third parties. If I may just take your lordship to that order, page 145, my lord. This was passed in a CRP which was disposed of earlier, my lord.
140?
145. I'll just take in your lordship to the relevant portion of the order, my lord.
Yes.
As per section 10, para 16, my lord, as per section 10 of the Act, the certificate of registration of a trade union may be withdrawn or cancelled by the registrar of trade union either on application of a trade union inviting the attention of the registrar of trade unions, or the registrar may suo motu take cognizance under the said section. There is no mention in the said provision about cancellation of registration of trade union on application of any other person. The said section permits the authority to cancel the registration of the trade union if it is obtained by fraud or mistake, but does not permit the authority to cancel the certificate of registration if the same is granted by mistake due to incorrect assessment or non-application of mind or mechanical act on the part of the authority. Now, page 147, very quickly, my lord. Para 21. Granting registration is a decision of the registrar. The official act done in official capacity is presumed to be legal and valid. The said act cannot again be nullified by the second decision of the registrar, which has no power to review. Legislative wisdom has specifically excluded an act of mistake by the registrar and power to review. Registration cannot be cancelled by registrar in exercise of power under section 10 of the Act. Does only the act of obtaining the registration certificate by fraud or mistake, that too by the person applying for registration, could only be a reason or ground for cancellation of the registration of the trade union. What is included within the purview of section 10 is the only act of mistake or fraud committed by the trade union applying for registration. The act of granting registration by mistake may occur due to incorrect assessment or non-application of mind or mechanical act on the part of the registrar, but such act cannot be rectified by section 10. It can only be rectified either by the appellate authority or writ court as the circumstances may demand. The fraud or mistake referred to under section 10 is required to be established as proved as any other fact. The factum of fraud or mistake essentially is a question of fact which needs to be established by pleading positive evidence. If the trade union obtains certificate either by mistake or fraud, and if it is proved by cogent and reliable evidence, then such certificate can alone be a subject matter of cancellation under section 10. In other words, any mistake in granting the registration is not within the ambit of the section. So basically observing all of this, that you cannot act on the behalf of complaint from others, you cannot correct mistakes, you can do it only on the ground of fraud. And the court said that since fraud is a question of fact, it has to be proved by leading evidence. And accordingly, the matter was remanded back to the Labour Court, directing parties to lead evidence. My lord, after the remand, my lord, the impugned order was passed, which your lordship finds at page 157, whereby the stay of the cancellation order was vacated.
Page number 120.
157. Lord, they filed for vacating of the stay of the cancellation, and the Learned Labor Court has vacated that stay. Now, reasonings. Your lordship can come straight to 166, where your lordship finds the relevant portion.
Yes.
Para 10 towards the bottom, my lord. Considering the nature of the dispute and pleadings of both sides discloses many mixed questions of fact which require proper adjudication in the original appeal, number 1 of 23, on proper appreciation of evidence and personal appearances of witnesses by both sides as their names of many vital persons involved in connection with the order dated 38/23. Therefore, considering all aspects, this court is of the considered opinion that without proper examination of witnesses involved in the main appeal, further extension of the stay order injunction order would cause undue delay in conducting expedite trial of the appeal. Hence, considering all the above, stay order dated 7/9/23 is vacated with immediate effect. Now, your lordship will appreciate, my lord, we are a trade union of more than 4,300 members, my lord. Now, all of a sudden, if the stay is vacated, that means we become a derecognized society. I'm sorry, a body. So therefore, my lord, considering that this order had far-reaching civil consequences, where I'm reduced to an unregistered body, the stay ought to have been continued. And the reason cited by the Labour Court is that if I continue with the stay, it will delay the further proceeding. So, my lord, considering that, my lord, this revision is filed, that since it's a statutory appeal, and whether the cancellation order is right or wrong is being adjudicated upon until the final decision is arrived at, this cancellation of the stay order should be, cancellation of the registration should be stayed, my lord. In fact, when the earlier CRP was filed, then also this honorable court made it clear that the cancellation should remain stayed. That is at page 134. One 135 is that's of course an interim order, because being mindful of the fact that if the cancellation takes effect, and they are the only representative from Assam with the national body at Delhi. Now, my lord, this is otherwise a rivalry, my lord, and the state between two local organizations, and therefore, my lord, they have been filing complaints alleging irregularity.
Lord Mr. P.D. Decker, Learned Court of this petition under Article 227 of the Constitution of India is referred by the petitioner, namely Chemist and Druggist Association of Assam, challenging the order dated 9/2/2025 and 21/2/2025 passed by the Learned Labor Court at Guwahati in this case number 1 of 2023, arising out of appeal number 1 of 2023, and thereby vacated the stay order dated 7/9/2023 and rejected the application filed under Order 41 Route 5 with Order 39 Route 1 and 2 deal with Section 151 of the Code of Civil Procedure. For stay of order dated 38/8/2023 till the issue thereof. Mr. Dekka, Learned Counsel for the petitioner submits that the petitioner has preferred the appeal number 1 of 2023 against
The order dated 38/20.
against the order dated
2023.
against the order dated 38/8/2023, wherein the learned presiding judge Labor Court was placed to grant stay, temporary stay.
No, 38/23 is the order of the Registrar of Trade Unions cancelling my registration. Then 7/9/23 is the stay of that order.
Okay, and in the said appeal, the petitioner organization has filed one application under Order 41, Rule 5, read with Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure for stay of the order dated 38/8/2023. And the learned Labor Court by order dated 10/2/2025 has granted stay.
7/9/2023 had granted stay. No? 7/9/2023. That is at 70.
On 7/9/2023 has granted stay of the order dated 38/8/2023 passed by the learned, passed by the registered.
Registrar.
Passed by the
Registrar.
registered. Passed by the registered. And thereafter, by order dated 21/2/2025. Is it correct?
Yes, yes, impugned.
The learned Labor Court, presiding judge and Labor Court Guwahati has vacated the earlier order.
Yes.
Earlier order. Mr. Decker further submits that till disposal of the appeal, there is a requirement for staying the order dated 38/8/2023 passed by the register. Passed by the register, but the learned Labor Court, without considering the same, has vacated the order, stay order, at the behest of the rival.
No, my lord may not say that because here the rival organization is
Not
not a
there.
part.
So that is your submission.
That is my
not
submission
objection.
insofar as that before the registrar, the rival organization had filed. Here, my lord, it is versus registrar and us one.
And therefore, Mr. Decker has consented to stay the order dated 38/8/2023 passed by the register till disposal of the appeal number 1 of 2020. Where having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition of record and also perused the order dated 38/8/2023. That order is at page number
Page number 157. my lord.
157.
57. The impugned order, my lord? Oh, that order is at page 17, my lord. The cancellation order. Seven. 38/23.
Page number 17.
17. That's the
Annexer one.
order.
Annexer 1.
Yes, yes. Page 19 is the operative portion.
And also peruse the order dated 10/2/2025 and 21/2/2025 passed by the learned Labor Court at Guwahati. In Miss Case number 1 of 2023, arising out of appeal number 1 of 2023. Let notice be issued to the respondent. Respondent returnable in 4 weeks, step be taken by registered post with AD and also by the process. And taking note of the submission of Mr. Leka, learned counsel for the petitioner. And also balancing the equity between the parties, the order dated 38/8/2023 passed by the register stands stay till returnable date.
Deeply obliged.
Number 3.
Lordship, this revision petition filed against the order dated 18/7/24
page number 47. The fact is that the present petitioner filed a divorce case before the family court against the respondent on the ground of cruelty and desertion. And that during the pendency of the case, the respondent number filed a petition is page number 32. And a petition for the direction to the petitioner to install inverter connection and separate electricity submitter in the living room of the respondent to ensure uninterrupted electricity supply. The fact is that their marriage was solemnized in the year 2017. After the
So there was a direction for installation of separate
Separate.
electric submitter
submitter in
in
the
the living
room.
room of the respondent.
There is an existing electricity connection in the room where the respondent is staying. The land is external land, and father of the peasant petitioner has constructed the house. The peasant petitioner has
Let
no,
notice go at this stage.
peasant petitioner has no right title over the said land.
But she is your wife,
Yes, yes. There is an
She has no right.
yeah.
despite of being your wife.
There is a existing electricity connection is there. Because I have no title, right and title of over the land and on the and the house where the she is living.
Heard me, sir?
DK Bordeloi.
Pardon?
DK Bordeloi.
Learned counsel for the petition. In this petition under Article 227 of the Constitution of India, read with section 151. Read with section 150, no, 115 and section 151 of the Code of Civil Procedure. The petitioner, namely Rintu Pormon, has challenged the order dated 18/7/2023. Passed by the learned principals as Family Court number 3, Kamrup at Guwahati in FC, civil case number 1729 of 20. It is to be noted here that by impugn order dated so the learned principal judge Family Court number 3, Kamrup Guwahati, has directed the petitioner hearing to install a separate electric submitter in the living room of the respondent. And the respondent and granted her liberty to install inverter in her living room by herself. The learned counsel for the petitioner submits that the petitioner has no right title over the said room, and that already electric connection is there in the living room of the petitioner. And as such, the impugn order is not sustainable. And therefore, it is contended to allow this application. The submission of learned counsel for the petitioner needs further consideration. That is not easily issued to the respondent returnable in 4 weeks to be taken by register post with AD and also by the person in order to come to the list after 4 weeks.
Lots of interim prayer is there.
Interim prayer will be considered on appearance of the other side.
Highly request.
Item number 4.
Lordship, I need seek a little accommodation, maybe fixed, adjourned for a week. I want to get up-to-date instruction.
Okay. As prayed for by Mr. M.S. Laskar, learned counsel for the petitioner, races shall leave the matter after a week so as to enable Mr. Laskar to obtain up-to-date instruction.
Item 5.
My lord, on last occasion, my lord. 1042 divide. Your Lordship, I pray before your Lordship that Supreme Court in a case decided, Supreme Court in a case decided that punishment will be given, supposing an injunction petition is subsequently dismissed. But during the pendency of that petition, if injunction is violated, the person concerned who violated is punishable for that period. That is the decision, my lord. So here in this case, my lord, what is the similarity with my case? My humble submission before your Lordship, I have filed a petition for extension. What happened, my lord? May I go to this original thing, my lord? What happened, my lord? My injunction petition was rejected by the court below. Thereafter, I came before your Lordship by filing an RFA. That RFA was remanded back due to increase of pecuniary jurisdiction. And your Lordship was pleased to observe that status quo order will be maintained regarding the shoot property. So after receiving the record also, my lord, district judge also continue with the status quo order. In the meantime, what happened, my lord? I filed a petition for extension. Extension was there on the last occasion. I filed a petition for extension again. Then that petition was rejected only on the ground that you see, you have filed a petition that already that status quo order has been violated by the opposite party. Now, my lord, my humble submission before your Lordship, opposite party violated the injunction petition, injunction order, status quo order, whether that can be a ground for rejection of my extension order, extension petition. My humble submission before your Lordship, learned court below is to consider my petition on merit. Consider my petition for extension on merit, not that the opposite party violated the status quo order, so my petition is infractuous. My humble submission before your Lordship, that approach of the learned trial court, my lord, is not proper. Why not proper, my lord? If that is the position of law, then what will happen, my lord? Everybody will come and violate the petition and extension order will not be granted. That cannot be the
No,
position.
Mr. Seth, you show me the decision of Supreme Court.
My lord. Yes, our decision to the Yes, sir. Come to this. It will. Was it to the book? So, my lord, it is handed over to your Lordship. Your Lordship will be pleased to see first paragraph that case, my lord, case has got similarity with me.
Also, show me the impugn order.
My lord, yes. Impugn order for extension.
133.
Huh?
133.
133, my lord.
133.
133, my lord. May I read, my lord?
Yes.
Both parties are represented. Learned counsel for the petitioner has filed petition number 384 of 2025. Prayed to extend the status quo order dated 27/3/2024 till the final disposal of the title appeal number 11 of 2024. This petition seems to be infractuous, since the petitioner has already filed another petition alleging that the status quo order has been violated. The matter is pending for hearing in Miss Case 96 of 2024. No useful purpose is likely to be served by passing an order of extension of status quo order. Now, my lord, my humble submission, my lord, only thing is this, my lord. Somebody violates the status quo order, that will not make my petition infractuous, my lord. That cannot be. My extension petition will be decided on merit, my lord. That is my humble submission.
Which is the relevant paragraph here?
My lord, paragraph 1 to 1 may be looked into, my lord. My lord, this is not the point of law, but factually, my lord, my case is similar with this.
So what is the outcome of this appeal?
This one, my lord. This one, my lord, your lordship will turn to page 12, para 12, my lord. Para 12, my lord. Para 12.
Sir, MSec, learned.
11, my lord. The same undertaking was re-emphasized a month later.
Okay, okay.
Yes, my lord.
This application under Article 227 of the Constitution of India, read in Section 151 of the Code of Civil Procedure, is prepared by the petitioner, namely Laila Begum, challenging the correctness or otherwise of the order dated 28/2/2025, passed in this case number 40 of 2024, arising out of title number 11 of 2024. Passed by the learned additional district judge number 2, Kamrup M. Guwahati, whereby the status quo order dated 27/3/2024 is vacated by rejecting the prayer for extension of status quo order. Mr. Say, learned counsel for the petitioners and that the petitioner has instituted one title suit number 303 of 2020, along with Mijik case number T29 of 20 before the learned civil judge senior division number 2, Kamrup and Guwahati, for declaration of a decree under the law of preemption under Mohammedan law or any other relevant law, and the same was rejected by order dated 1/8/2022. Challenging the aforesaid rejection order, the petitioner filed one RFA number 42 of 2022 along with IA civil number 3483 of 2022 before this court. And this court, by order dated 25/11/2022, was pleased to direct the parties to maintain status quo on that day. And subsequently, due to amendment of pecuniary jurisdiction the said case was transferred to the Court of Learned District Judge Kamrup M. Guwahati. And thereafter, the Learned District Judge was pleased to extend the status quo order. But by the impugn order dated 20th/2/2025, the Learned District Judge has rejected the petition filed by the petitioner, and consequently the order passed by this court on 25/11/2022 stands vacated. And being aggrieved, the petitioner approached this court by filing the present petition. Mr. Say, further submit that the ground for rejection of the petition for extension of status quo is not a sound reasoning, and if on that ground, sound reasoning, as the learned trial court has rejected the petition on the ground of being infectious, since the petitioner has already filed another petition alleging that status quo order has been violated. And also by holding that no useful purpose will be served by passing an order for extension of status quo. And therefore, Mr. Sheikh submits that the learned trial court may be directed to decide the petition filed by the petitioner on merit. Where having heard the submission of Mr. Singh, learned counsel for the petitioner, I have carefully gone through the petition and the class of record and also perused the impugn order dated 20th to 2025 passed by the learned trial court in its case number 40 of 2024 arising out of title appeal number 11 of, and also perused the order dated 20th, order dated 25/11/2022 passed by this court. Passed by this court. And it appears that the learned trial court has dismissed the petition filed by the petitioner for extension of the status quo till final disposal of the title appeal number 11 of 2022. On the ground that the petition seems to be infructuous since the petitioner has already filed another petition alleging that the status quo order has been violated. And that no useful purpose will be served by passing an order of extension of status quo order. The ground for dismissal of the petition filed by the petitioner for extension of the status quo order seems to be not sound convincing. Not sound convincing. The learned trial court ought to have considered the said petition on merit. Mr. Sheikh, learned counsel for the petitioner, has rightly pointed this out at the time of our taking note of above. And also considering the given facts and circumstances of the record, its court is inclined to set aside the impugn order dated 20th to 2025 passed by the learned trial court at its motion itself, and also to direct the learned trial court to consider the petition for its extension of the status quo order on the basis of on merit. In terms of above, there's a petition stands dispose of the motion itself.
All right, sir.
Item number 6.
My pleasure. But if this revision is filed challenging the order dated for 5/2/2025, passed in case number 37 of 2022, arising out of title execution case number 5 of 2018. Impugn order is at page 85. The case of the petition is that the predecessor of the petitioners filed title suit number 302/2013 before the court of Munshi Borbe.
Where is the impugn order?
Impugn order is at page 85, Lordship. The fact of the case is that, Lordship, the predecessor of the petitioners filed a title suit before the Munshi Borpeta. In the title suit, the original defendant filed written statement along with his counterclaim. And during the pendency of the title suit, Lordship, the original defendant died. And in his place, all the known legal representatives are substituted by the petitioners. And notices are served to the substituted defendants. But in spite of getting notice, they did not appear and the suit proceeded ex parte. And by judgment and decree dated 23/10/2017, the suit is decreed in favor of the plaintiff. Thereafter, the decree holder filed a title execution case, lordship, which is the number is title execution case number 5/2028, 2018. In the said title should also the defendants are issued notices.
Okay.
But suddenly in 2018, the present respondent appeared before the trial court and filed a petition under Order 9 Rule 13 and Order 1 Rule 10 Sub Rule 2 for setting aside the ex parte judgment and decree and to add her as a defendant. That was number is miscase number 53/18, and by order dated 24/10/19, that miscase was dismissed. Against that order, lordship, the respondent filed an appeal which was numbered as miscellaneous appeal number 4/19. The said appeal was also dismissed, lordship. And thereafter, after 7 years, the petitioners, the respondent filed a miscase which is numbered as 37/2024 under Order 21 Rule 97, 99, and 101 of the CPC, lordship. And in that miscase, by order dated 5/2025, the respondent was allowed to adduce her evidence, lordship.
So you have been directed to adduce evidence, right?
Yes, respondents have been directed. Again, that order I
Okay.
filed this.
Okay. So what wrong with the order?
Admittedly, lordship, this order has been filed after a gap of 7 years. Without supported by any condemnation petition, lordship.
But what Order 21 Rule 97 speaks?
Resistance or obstruction to possession of immovable property, where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person obtaining possession of the property, he may make an application to the court complaining such resistance or obstruction. Lordship, this order is applicable by to the decree holder, lordship. And the decree holder can maintain an application under Order 21 Rule 97 or 99, lordship. And here no time limit was.
No, not only decree holder. See the wording. You see the wordings.
For the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of a decree is resisted. And the decree holder is resisted by any person, lordship. He may make an application to the court complaining of such resistance or obstruction.
Here you are the decree holder.
I am the decree holder.
So you have filed the title execution case.
Yes, lordship.
So there the respondent herein file application.
Respondent here filed application claiming that he is the daughter of the dependent and she was not substituted after the death of her father. That petition was dismissed. Against that petition, she had filed a miscellaneous application, which was also dismissed by the appellate court. Thereafter, she has filed the petition under Order 21, Rule 97, 99, and 101. After a gap of 7 years, Lordship, without any condemnation petition. That petition was time
What
barred.
is the period of limitation?
No specific petition was period was specified, Lordship, in the Limitation Act.
Then
So in that case, 3 years is the limitation period. As per Article 137 of the Limitation Act.
whether you have pointed out to the learned court at the time of hearing.
Yes, Lordship. We have made that at the ground, Lordship.
No, whether you have pointed out this aspect to the learned trial court or executing court.
Lordship. We will pointed out that. And even if Lordship, if not, even if limited not set up as a defense, Lordship, then also.
Let notice go at this instance. Let the other side appear.
Lordship.
Heard, Mr. Your good name, please.
M. Rana.
M. Rana, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, is prepared by the petitioner. Four petitioners, namely Satendra Das, Sanjay Das, Solen Das, and Joymati Das, challenging the correctness or otherwise of the order dated 5/2/2025 passed by the learned Munsif number 1 Baksa in Mijay case number 37 of 2024 in title execution case number 5 of 2018. Is to be noted here that by the impugn order dated 5/2/2025, the learned Munsif number 1 Baksa in Mijay case number 37 of 2024 in title execution case number 5 of 2018. Has granted an opportunity to the petitioner to the respondent herein to present her case upon the suit land by way of adducing evidence as per order 21 rule 97, 99 and 101 of the Code of Civil Procedure. The learned counsel for the petitioner submits that the learned trial court has admitted the petition after 7 years.
After 7 years and 12
After
days.
7 years and without a condemnation petition for the delay being filed. And as such, the impugn order is not sustainable and therefore it is contented to set it aside. The submission of the learned counsel for the petitioner needs further consideration. At this instance, notice be issued to the respondent returnable in 4 weeks. The be taken by registered post to AD and also by usual process within a week. List after 4 weeks. Interim care of the petitioner will be considered on next returnable date.
So item number 7.
So this is 482 of BNSS lordship.
My lord, before my lineup can start, my lord, I think one of this matter may be listed before appropriate ban.
No,
This
no.
was page 34.
Hmm.
One,
The earlier perhaps a discord was placed to reject us.
Yes, Lordship, today morning I have
But they-
enquired.
but-
One bail application was.
but they have not
No.
annexed that order here.
No, he has furnished a copy of the same.
Oh, my lord. Then- But I don't have that copy in my petition. My lord.
Lordship, in this case,
Pardon?
That copy I don't have in my petition. My lord.
Lordship,
Yes.
someone was issued to the petitioner showing him as absconder in the charge sheet. Otherwise, Lordship, all the accused persons, they have got bail from the courts, except the present petitioner, Lordship. So, Lordship, he may be
My lord.
protected, Lordship, and he will like to face the.
So circuit is submitted.
Lordship?
Circuit submitted.
Yes, Lord. And someone was issued to. him,
You.
Lordship. Yes,
When the next date is fixed.
yes, Lordship. 4/3, it was fixed on 4/3/2025, Lordship,
Or
for appearance.
or
Appearance.
who is that?
Lordship, in the summon, Lordship,
Page number
page number, yes, Lordship, 32, Lordship.
32.
Yes, Lordship. It was, Lordship,
4/3.
4/3.
So on that day you have not appeared.
Lordship, perhaps a step has been taken by the English Council.
Pardon?
Steps has been taken by the English Council.
Okay.
My lord, otherwise this is a POCSO case, my lord. Notice should
Okay.
go, my lord.
Notice has to go.
Yes, my lord.
Lordship, he is ready to, Lordship. He is ready to,
No, that's
Lordship.
all right, but there is a direction of division bench that in POCSO matters notice should go
Normally,
to
it's Lordship, but to meet
the comment and victim.
to meet the acts of justice. Otherwise, there
We'll
is
take a step, we'll see.
okay.
Heard Mr. A.J. Ahmed, learned counsel for the petitioner. Now, for the applicant, this application under section 482 of PNSS 2023 is preferred by applicant Noor Sodagor alias Butu Mia, who has been apprehending arrested in connection with special within bracket P case number 291 of 2024 arising out of Madrasar PS case number 703 of 2021 under section 120B 354 P84 506 34 IPC read with section 8 of the POCSO Act and read with section 67A of the IT Act pending before the court of learned special judge of Sarmana Mankasar. Mr. Ahmed, learned counsel for the petitioner submits that after completion of investigation, police submitted charge sheet against the present petitioner and someone has been issued to him fixing the matter on 4/3/2025. And that the petitioner is ready to face the trial. And therefore, it is contented to allow this application. However, it appears that apart from the offenses under IPC, the case is also registered under section 8 of the POCSO Act. And as such, there is a requirement for issuance of notice to the informant struck victim. Accordingly, it is provided that the learned counsel for the applicant shall take step upon respondent number 2 to the registry of this court within 2 working days from today. In the meantime, registry shall call for the scanned copy of the record from the learned trial court. List the matter after
You can fix date
On 7 April.
7 April.
I'm also.
Item number 41.
Lordship, I beg to mention the item at 2 o'clock. The matter has not been recorded. Take 2 o'clock, Lordship. I being apologized. 43.
This is second petition. Earlier one is rejected by your lordship. There are 4 petitioners. One has been granted, another to be rejected. And that order you kindly see it is 19 to 23.
This is also POXO case.
Foxo, yes, Foxo,
Let notice go that this is the
my lord. And
Heard
CP
Mr. A. Rossett, learned counsel for the applicant. His application under section 482 of the BNSS 2023. Also heard Sir Kosik, learned that under section 482 of the BNSS 2023 by 3 applicants, namely Rahmat Ali, Saifuddin, alias Sahabuddin, and Azupa Bibi, who have been apprehending arrest in connection with Dhuguri PS case number 376 of 2024 under section 120B, 376, 307 IPC, read with section 6 of the POXO Act. Mr. Rosid, learned counsel for the applicant, submits that this is the second application deferred by the applicants, and the earlier application was dismissed by this court by the order dated. Where is that order?
page 20, my lord. 4 to 25.
Order dated 4/2/2029 in BA number, AB number 10 of 2025. Since the case has been registered under section 6 of the POXO Act also, that this is notice be issued to the respondent.
Well,
Number 2,
Pros,
to the registry of this court within 2 working days from today. Is it solicited case?
my instruction no substitute.
In the meantime, Mr. Kosik, learned additional PP shall produce the case diary before this court on same date, 7/4. 7/4.
Items for admission, item number 8, Parthad matter.
In this case, as
Yes.
is applying lawsuit, for
Yeah.
timing lawsuit is coming.
Pardon?
As thus is applying for higher division lawsuit,
Oh.
as thus, the timing lawsuit is
Okay.
on another
Okay, after some time.
lawsuit.
Item 9. Parthad matter.
I have submitted the letter to the routine ag on that itself, lawfully. It was sent to the finance on 7/3/2025. This is the. Now it is pending before a finance lawsuit. I have informed P. Naga, he is on legs in another court lawsuit. That's why he is unable to come right now lawsuit. Lawsuit, can you take it after?
After some time,
Yes. Only that maybe it's kept in the record lawsuit, that letter.
Oh, Mr. Sisse, furnish a copy to.
This is a complication to ask. Yes, I can find it.
Item number 10, Parthad matter.
May it please, your lordship.
Yes.
So last order may be perused. So last order was direction was sought from Mr. Khataniar. Order dated 11/3/2025. This matter, lordship may remember, pertains to return of salary with interest and along with commuted leave, which was deducted unauthorizedly. Total number of commuted leave was 250. They recorded 235. I'll just try to
Sir Gogoi, Khatoniar is available. Mr. Khatoniar is available. Report. Pardon?
He's on legs, Your Lordship.
Okay, kindly inform him.
Yes, Lordship, I'll inform.
But
Number 11, pardon matter.
May it pleases your lordship.
yes,
Your lordship, on the last date, the counsel for the respondent was asked to get instruction whether the respondent has vacated the suit premises or not.
yes.
For the last 3 days, they have not been able to furnish that information. As per my information goes, he has not vacated the suit premises. He is still occupying the suit premises in spite of having received the decretal amount as per the memorandum of agreement entered into in between them on 8th January 2025.
But where is the council?
Council still is absent. He was absent last week also. Someone
No,
appeared
on
and
the other day, one was Mbora
Mbora,
appeared.
yes, took adjournment on his behalf.
Whether Mr. Chaudhary is present in the court? SP Chaudhary.
I have not met him.
No. Okay. SP Chaudhary. Cooperative. Wait for some time.
Deeply offended.
Right.
Item 14, under order 41, rule 266. Item 14.
May it please your loss.
Yes.
My lord, this cross objection has been filed by us. We have entered appearance in the second appeal already admitted by the other side. We are respondent number 1 to 4, my lord. So this cross objection we have filed under the provisions, order 41, rule 22, my lord. So the second appeal is admitted, it is for hearing, it will come up for hearing. This cross objection is filed by us, page 6, my last page of our application, my lord.
Order 41 rule
Rule 22, my lord.
22.
We have entered appearance as respondent 1 to 4. And we have filed this cross objection also in the appeal, which may be tagged with the appeal and may be heard in the due course along with the appeal matter. So we have taken up this.
The appeal is ready for hearing.
Lordship.
My lord,
Appeal is ready for hearing.
The LCR has been received, Lordship.
Received. So we can heard both the matter together.
Lordship.
it is up to your lordships. Both the matter may be tagged and may be heard in due course.
Okay. Heard Mr. Mazhar, yeah, learned counsel for the cross objector.
Yes.
Then also heard Madam for the
Appellant, main
appellant,
appellant matter.
for the appellant. It is submitted at the bar that this cross objection may be heard together with the RSA number 173.
Yes,
Lordship.
RSA number
173 of 2023.
2023. Wherein service already completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that this cross objection with tagged with RSA number 173 of 2023 and both the matter will be heard together on next day. Please the matter after in usual course.
Much obliged, madam.
Deeply.
Item 15.
Right, please, my lord.
Yes.
My lord, this is a regular second appeal, my lord. My lord will find the substantial question of law at page number 6. Basically, at this juncture, I'm only harping upon
the first substantial question of law because there has been a irregularity that has been done by the first appellate court, my lord. If I may please that, my lord.
When this petition is supposed to be decided?
My lord,
This petition under Order 41, Rule 27,
my lord, it is supposed to be decided before the appeal is considered, my lord.
and when it
Despite-
was considered? At the time of hearing the appeal?
Yes, my lord. Despite
be
there being direction of this honorable court, despite there being a direction of this honorable court, because initially what happened, my lord, along with the appeal, I filed the application. They have filed the written objection, my lord, to that application. The court has dismissed the application. I came to this honorable court by way of an CRP, my lord. The court on the very first day set aside the order and has issued direction to the lower court that, my lord, the first appellate court, that, my lord, this application should be heard. But, my lord, completely ignoring that order, sidelining that order, my application was heard along with the appeal when there is a clear direction of the honorable apex court, my lord, that the such application under order 41 rule 27 should be heard before, my lord,
Deciding the appeal.
Yes, my lord. May I please raise the judgment also, my lord? So this is the issue that needs to be considered. If this issue is allowed, my lord, then, my lord, it will have to be sent to the first appellate court to decide the application first, then decide the appeal, my lord.
Third, Mr. Arsenso, learned counsel for the appellant. This appeal under Section 100, read with Order 41, Rule 27. Read with Section 151 of the Code of Civil Procedure is directed against the judgment dated 7/7/2023 and decree dated 7/7/2023. Passed by the learned additional district judge FTC number 2 Tinsukia entitled appeal number 2 of 2017. It is to be noted here that by the impugned judgment and decree dated printo, the learned first appellate court has affirmed the judgment and judgment dated 28/2/2017 and decree dated 4/3/2017 passed by the learned civil judge in Sukia in title suit number 2 of 2011. There is a memo of appeal and the grounds mentioned therein and the suggested substantive questions of law. And also there is the impugned judgment and decree dated 7/7/2023 passed by the learned first appellate court and also by the learned civil judge in Sukia entitled to number 2 of 2011. The second appeal is admitted on the following substantial question of law. Number 1, whether the learned first appellate court was justified in deciding the application number 1917 of 2018 filed under Order 41, Rule 27 of the Code of Civil Procedure against the appellant at the time of passing the final judgment and decree dated 7/7/2020. The court may also consider framing of further substantial question of law if found necessary at the time of hearing. After giving notice to both the parties. Issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also the usual process within a week from today. Not respondents, only respond. Recessal call for the records from the learned courts below. This is the matter after 4 weeks.
Timing item 10.
Yes, Mr. Mahanta.
Yes, Your Lordship. That amount has been given to us by deducting 10% income tax. That is,
Yes, what wrong with the order?
I don't think income tax deduction for that amount below 3 lakhs probably will not arise to my understanding. Subject to correction by my senior friend.
Yes, Mr. Katonier.
Normal procedure, my lord.
Normal procedure, Lordship. What has I have checked out?
No, no. In a clause number F, it is stated income
Yes.
tax whenever necessary should be deducted at source.
Yes, wherever necessary. So if it is
If it is not necessary, definitely they will not deduct it.
okay. The other part of the prayer, Lordship, that committed leave, other part of the prayer which was instruction was sought for the deduction of committed leave to 50 days.
As regards the statements of paragraph 8, my lord, I need some time to obtain the instruction, my lord. The contention made in the paragraph 8 of the petition.
What was the paragraph number 8?
Paragraph number 8, my lord, is saying that, my lord, it was his earned leave was shown as 235 instead of 250, my lord. Page 8. And it is earned leave showing it to be 235 days instead of 250. So that, for that part, my lord, I need some time to obtain instruction.
Oh, why you could not obtain instruction at the same time?
But it is my fault, my lord, because I have to obtain instruction from the inspector of schools, my lord. There is some miscommunication from my side, my lord. That is my lord.
Okay.
If it
Heard
can be
Mr.
taken,
Mahanta, learned counsel for the petitioner, and Mr. Katonier for the respondent authorities.
Next week, my lord, immediately.
Pursuant to order of this court dated 11/3/2025, Mr. Katonier has obtained necessary instruction. Then advise this court that the respondent authorities has already sanctioned a sum of rupees 2,76,813 being the arrear payment. And further, Mr. Katonier submits that he may be granted 1 week time to enable to obtain necessary instruction in respect of adjustment of 235 days of unutilized earned leave instead of 250 days.
yes.
Care of Mr. Katonier is allowed. Recital is the matter after 1 week. As per third, the letter produced, written instruction produced by Mr. Katonier shall be part of the record.
One second, Your Lordship. Second. Okay. Obliged.
Obliged.
Item number 16 matters for orders. Item 16. 16 and 46.
May it please your lordship?
Hmm.
Lordship, in this case, we have taken fresh steps upon respondent number 2. Because the earlier insurance company, learned advocate is not present.
Hmm.
The AD card has not yet been received till date. So new engaged counsel is not yet being engaged, lordship. It is a 2016 matter. Though the wakalatnama was filed during that period
Hmm.
for the insurance company, now no learned counsel appearing on behalf of the insurance company is available. On that regard, we have taken fresh steps. But till date, no wakalatnama is being filed on behalf of the insurance company.
Then Madam Iwafa,
Question number 1, claimant.
claimant. Who filed this appeal?
The owner of the vehicle, your lordship.
Owner of the vehicle.
Yes.
Is there any standing counsel for National Insurance Company Limited?
If there are no standing counsel, we appear as panel counsel.
Panel counsel.
I'm there, but panel not standing.
So, Madam, can you obtain instruction in respect of this appeal?
Oh, okay. Muk number to Didi, but I can inform them that they need to.
You can inform them.
Or if lordship directs me, then I can appear, but otherwise I cannot appear. I can inform them.
Okay. Okay, we will issue direction to you to obtain instruction.
Yes, Lord.
Third Miss P. Bora.
A. Bora.
A. Bora. Learned counsel for the appellant. And Madam
SD cycle.
for respondent number?
1.
Respondent number 1. Ms. Bora, learned counsel for the appellant submits that she has taken a step upon the respondent number 2. The branch manager, National Insurance Company Limited. But neither AD card nor unserved notice has been received. However, learned panel counsel, Miss R.D. Mazumdar, learned panel counsel, Madam.
Yes, Lord.
Panel counsel for the National Insurance Company Limited is present in the court, and she is requested to obtain necessary instruction in respect of this appeal. And place the same before this court on next step. List the matter on. This is 2016 matter. We'll fix it at 22nd April.
My hospital goes up.
So who filed this IA number 2153?
This one was filed by the owner of the vehicle. That was the appellant in the main case. This IA was filed under Order 41, Rule 27 for reducing additional evidence, your lordship.
Okay, we let the other side appear. We'll consider later. Registrar shall take this IA number 2153 of 2023 along with MSC appeal number 113 of 2016.
Standing item 7.
Also, I have tried to communicate with the respondent, but I have not received any such response whether he has vacated the premises. But I have talked to the learned friend. He's saying that till date he has
Not
not
vacated.
vacated. Not
He has
vacated.
not
Probably I'll
vacated.
file one affidavit clarifying his stand, whether he has vacated and what is the reason for not vacating.
Clarifying.
Clarifying why he has not vacated or what is his position with regard to vacating the suit premises. Can be taken up any day in the next week, Lordship.
Next week.
Next week.
No,
Already
you have
3
already
dates have been
received the
passed.
amount. Thereafter, you were supposed to take it.
Exactly, Lordship. I don't know why, whether it has been vacated or not.
It
because-
is not vacated. In the month of January only he has received the decretal amount.
But they can proceed with the execution because the execution case has been filed. So they can proceed very well, execute the decree. Because there is no such stay so far as the execution is concerned.
Lordship, my prayer at this point is only that the money has been received, dictatorial amount has been paid, that may be recorded and this matter may be disposed of. We will approach the executing court because we also have filed an execution case, title execution 12 of 2024. So we can approach in that case and we can, by through the process of the court, that is through the civil bailiff, we can vacate him.
Yeah.
Yes, sir. That is the thing. Since the execution case is pending, so can then proceed with the execution case.
My only prayer is that it should be, the payment has been made, that may be
If the
reflected.
defendant is in possession of the property, they can execute the decree to obtain the possession of the decree.
Heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. S.P. Chaudhary, learned counsel for the respondent. Mr. Chaudhary submits that though he tried on several occasions, he could not contract with the respondent.
I have got the information, but the reason he is not specifying why he is not vacated the premises. That means he is saying that I have vacated. At the same time, he is saying I have not vacated. But there is some sort of confusion. He is saying that I have some sort of this tenancy agreement with the.
No, whether you have been able to contact him.
I've been able to contact, but the thing is that he is not clarifying what he has done. So that is the reason why I thought that it's better to file an affidavit clarifying his position, why he has not vacated. So since the execution case is there, so he can proceed with the execution case also.
As per his instruction, the respondent herein has already vacated the premises. But Mr. Ahmed, learned counsel for the petitioner, submits that the petitioner has already returned the amount of rupees 50 lakhs.
Of 76 lakhs.
76 lakhs on who is that?
On 8/1/2025.
8/1/2025. And in spite of receiving the amount, the premises has not been vacated by the respondent. Further, Mr. Ahmed submits that he has already filed an execution case before the learned executing court, and the same is pending there. And as such, this CRPIO may be closed. Taking note of the submission of learned counsel for both the parties, this CRPIO stands closed.
Lordship, with the liberty to approach the executive court.
No, that is already there. Why liberty is required?
Deeply obliged.
Item number, this is 17.
What is service awaited, Lord, on sole respondent?
You want to take press step?
Last occasion, we have taken step on 21 March, Lordship. So wait for.
Okay.
Public.
Heard Mr. U.S. Borgumai, learned counsel for the applicant. Office not dated. Mr. Borgumai, learned counsel for the applicant, submits that he has taken step in the month of
March.
On which
21 March. 21.
21 March.
Public.
21 March. And as such, it is provided that rest shall list the matter after 2 weeks, awaiting service report upon the respondent.
Public.
Number 18.
Hey, I go to settle. Right. The petitioner is done with liberty to pursue the execution.
With visual lordship.
Item 18.
Both the LCRs have been received, lordship.
So matter is ready for hearing.
Yes.
The other side?
Other side is informed that they have some difficulty today.
Okay. Heard Mr.
DS Dekar.
DS Dekar, learned counsel for the petitioner. Now for the appellant. None appears for the respondent, not all. Mr. Dekar submits that LCR from both the courts has been received. And as such, the matter is ready for hearing. Accordingly, it is provided that this shall list the matter for hearing in usual course.
Item number 19 and 44.
May, Your Lordship. Lord, in this case, actually, the discussion about not amicable settlements is on here. So may I have another date note so that we can come at an amicable settlement in the court?
So adjournment was earlier granted, so as to settle the matter amicably.
My lord.
What happened there?
But that actually it is about to be finalized, my lord.
Okay,
That as I have the instruction, but another opportunity may be given, my lord, and the matter may be listed after some time, my lord. Then we will inform the court that.
okay. Heard, Mr.
A. Ali, my lord.
A. Ali, A or Y?
A. Ali, my lord.
A. Ali, learned counsel for the petitioner, and Mr.
W. Rahman on behalf of Mr. K. Golida in item number 19 only, Lordship. Respondent number 1 and 2.
Mr. Your name?
W. Rahman.
W. Rahman, learned counsel appearing on behalf of Mr.
K. Kalita.
K. Kolita, learned counsel for the respondent number 1 and 2. Mr. Ali, learned counsel for the petitioner submits that negotiation for amicable settlement of the dispute is going on between the parties, and some time may be granted to settle the same. Here is accordingly allowed. Recess of the matter after vacation.
My lord.
After
My lord, may I pray that, my lord, interim is there. So till then, my lord, that may.
interim order.
My lord.
Till then, interim order shall continue.
My lord.
Who filed this IA 44?
Petitioner will. Because for suspending the operation of the impugn order.
So whether any order is passed here?
No, my lord.
No.
Because, my lord, yes, interim was granted, my lord.
In the main petition, interim
My lord,
granted. Okay. Recess shall take this IA number 532 of 2023 along with the CRP number
27, 2023, my lord.
CRB number 27, 2023 and list the matter immediately after reopening of the vacation.
My lord. I'm obliged, my lord.
Item 20.
In this case, I am newly engaged for sole respondent.
Okay.
Lordship, I am for respondent. Lordship, today
You are for? You are for?
Respondent.
Respondent or appellant or petitioner?
I am for the petitioner.
You are.
Lordship, the matter will come up for admission.
Admission.
Yes, because sorry. After vacation.
After vacation.
Yes.
Heard Ms. S. Dasgupta, learned counsel for the petitioner, and Mr. Purkaiso for respondent.
Sole respondent.
Sole respondent. Mr. Purkaiso submits that he has been engaged newly in this case and he prays for listing the matter
For admission.
for admission after vacation. There is accordingly allowed. Let's submit the matter in admission column immediately after reopening.
Lordship, there is an interim lordship that.
Interim order passed earlier.
Much obliged, Lordship.
Item number 21 and 45.
Wait, this is your lordship. Lordship, it was already admitted, and on the date of admission in the appeal itself, we were directed to deposit 50%. Later on, we filed a stay petition, lordship. That is item 45. Lordship may stay the impugned judgment. And service is complete, so case can be heard.
My lord, I filed an application for withdrawal of the amount, my lord. Whether it is come.
It is not there.
I mentioned question.
So, Madam, virtually this IA filed by you become infractions because already in the main order we have reflected state the order. So, the IA filed by Mr. Bhattacharya is not available right now.
Lordship, my prayer will be, Lordship, that the matter can be, in fact, we discussed in the morning also, that just after Bihu, the next hearing day on Tuesday.
LCR has come, my lord.
LCR has
can be
come,
heard at-
services, it can be
Finally.
finally heard, Lordship. On 22nd, Lordship, if Lordship pleases.
Well, it may be also listed with the, we have also filed a counter for enhancement, that is MSC appeal 195 of 23.
আমাকে একটা copy দিয়ে দিব।
Issue to Abu to.
নাই দিয়া, copy দিয়া।
So this might be clubbed together and can be heard.
195 of
195 2023 maybe.
23.
Full law more purchase oriented insurance.
But in that appeal also you have to serve the notice.
Already we have taken the steps, my lord, as per the court's order, but she has not received a copy. I will give the copy to her. Because the order is there also.
So, Madam, why you are objecting in releasing the amount?
Lordship, because then my appeal itself becomes infructuous. Lordship, this is a injury case and the doctor in one evidence says that it was amputed, his hand, and then another he says it was a fracture. And this person, he was in the army and he kept on working even after the accident till 2017. He retired at the age of 55 and 30 years of service because of superannuation, because in army they do not allow beyond 30 years. So that was no way related to the injuries. And as Rajkumar Ajay Kumar says that Lordship, injury, disability itself won't entitle a person for loss of earning if he has not really lost the earning.
My lord,
That is,
so far my learned friend says he has been given the retirement on the basis of the disability, my lord, by the army.
no, no.
Yes. Earlier it was remanded back.
No, Lordship,
My lord, that
accident
letter
took
is not
place.
for the argument, my lord, because
Huh.
earlier they have also come here. Then it was remanded back to the again for a retrial.
Okay.
And it is not.
Whether the record has been received?
Yes, my
Yes,
LC.
Okay. Heard Miss R.D. Mazumdar, learned counsel for the appellant, and Mr. Bhattacharya for respondent number?
One.
Respondent number 1.
For respondent to receive by her husband, Lordship. As per office note, Lordship. 23/7/24.
Office note dated
23/7/24.
There are altogether 3 respondents. You are for respondent number 1.
1.
Then what about this respondent number 3, driver?
Lordship, in fact, he is not necessary because the appeal itself is on quantum. We are not denying.
Okay.
He may be
So
striked
will
out.
strike of his.
Yes, Lordship. Oh, no. 1 and 3 file wakalatnama, Lordship. Lordship will peruse office note dated 6/6/24. Respondent 1 and 3 file wakalatnama.
1 to what?
1 to apuni, 3 you file korise.
3 7 to one.
Okay.
No, driver.
Driver.
2 হোৱা নাছিল, so এতিয়া 2 ৰো হৈ গ'ল.
Office note dated 23rd/7/2024 indicates that notice upon respondent number 2 has been served, but the respondent number 2 remain unrepresented today. Respondent number 3 also unrepresented today, though what counsel has filed his Wakalatnama as indicated by the office note. In the office note dated 6/6/2024, the service appears to be completed. And the LCR has also been received. And it is submitted by learned advocates of both the parties that the matter may be listed for final hearing. There is accordingly allowed. Recessal is the matter.
My lord, it may come with the MSc.
Yes, yes. 29th of April. And Mr. Bhattacharya further submits that the respondent number 1 also filed one appeal.
MSc appeal number 195
MSc appeal number 195 of
of 24.
2023 for
24, my lord. 24.
23
24, my lord.
for
Huh. 24.
24
195
for enhancement of the amount. And both the matter may be met together, take together, that may be heard together. There is accordingly allowed list of matter on 29.
29.
Highly obliged.
Item,
Uh,
item 22.
the IA number number IA number 1855 of 2023 becoming purchase in view of the order passed in the MSc appeal number 251 of 2023 dated 28/6/2023 as the relief rate in the IA has already been granted in the MSc appeal.
Obliged.
Item 22.
May it please, my lord. My lord, services are complete otherwise. Respondent number 128 has been represented by my learned friend. The Wakalatnama has been filed. In respect of respondent number 9, notice has been served by means of usual process. It is reflected in office note dated 19/2/2025, my lord.
Mr. Das for respondent number 1 to 8, madam. 1 to 8. Heard, Mr.
N. Chaudhary.
N. Chaudhary, learned counsel for the
Petitioners.
petitioners, and Mr. Ace Das for respondent number 1 to 8.
Total of 9 respondents, my lord.
Office note dated 19/2/2025 indicates that service upon respondent number 9 completed, but respondent number 9 remain unrepresented today. To recessal list the matter after vacation for admission hearing.
My lord, the interim order is there.
Interim order pass earlier shall continue.
Deeply obliged, my lord.
23.
Service is completed, problem. Item 23.
Service completed.
Lord. Office note dated 9/10/24, Lord.
Heard, Mr. Ndeka, learned counsel for the petitioner, none appears for the respondent on both. List the matter for
Probably hearing, Lords.
hearing after or before vacation.
After vacation.
Let's list the matter for hearing after vacation.
24.
Interim shall continue.
Interim order pass earlier shall continue.
My lord, this is a revision, fixed for orders today, maybe fixed for admission.
Okay. Heard Mr. L. Talukar, learned counsel for the petitioner, and Mr.
G. Bharadwaj.
J. Bertel, the learned counsel for the respondent. Since service already completed and the parties also entered appearance, this is the matter for admission. After vacation,
Highly obliged.
26.
May it please your lordship. As per office note dated 19/2/2025, the service in regard to respondent number 2 has returned answer with the comments as addressee has refused the service. So may be accepted in view of this office note. And service in regard to usual process, in regard to that, the daughter has accepted in regard to respondent 2. And regarding 3, she has said that 3 has expired.
3 expired.
3 has expired.
So is there any requirement for
3,
treatment of the legal hairs?
because 2 is the wife of 3. So 3 can be struck off otherwise.
Mr. Chakraborty, you are for respondent number 1.
I'm the principal respondent. The other two are the pro forma respondents.
Okay. Heard Mr. S. Dotto, learned counsel for the petitioner, and Mr. Chakraborty for respondent number 1. Office note dated 19/2/2025 indicates that respondent number 2 refused to accept the notice. And the said office note also indicates that respondent number 3 suffered demise. And respondent number 3 is the
Respondent number 2 is the wife of respondent number 3.
respondent number 2 is the wife of respondent number 3. And being represented by the respondent number 2, the name of respondent number 3 may be struck up from the array of the respondents of this CRP. Accordingly, taking note of submission of Mr. Dotto, learned counsel for the petitioner, the name of respondent number 3 is struck up from the array of this petition at the cost and risk of the petitioner. Since service completed, now let's establish the matter for admission.
My lord, only prayer, can there be a date? They're enjoying an interim order, my lord. It's a tenancy matter, eviction, my lord, decree against me. I'm the landlord.
When do you want?
After vacation, my lord, any date, my lord.
Okay, let's establish the matter on
24th April.
24th, deeply obliged.
Till then, the interim may be extended, your lord.
Okay, interim order passed earlier shall continue.
Obliged.
Deeply obliged.
27.
May I please your lordship? Lordship, as per office note dated 23/25, your lordship, respondent number 1 to 9 have filed their wakalatnama, your lordship. 10, 12, and 13, AD card has been received back, but the signature does not tally with the respondent name, your lordship. And 11 service await, your lordship.
I'm appearing for respondent number 6 to 9. my lord.
1 to
5.
So you have to take fresh step upon respondent number 10, 12, and 13.
Lordship. Lordship. 11 service await, your lordship.
Oh, okay, we will await service report upon respondent number 11. But you take fresh step
Lordship.
on 10, 12, and 13.
Lordship.
Heard miss, your good name,
F.
please.
Jamal.
Learned counsel for the petitioner, and Mr. SD Purkesto, learned counsel for the respondent number 6 to
9.
9, and Mr. Learned counsel for the respondent number 1 to 5. 1 to 5. Office note dated 20th 3/2025 indicates that AD card. Respect of service of notice upon respondent number 10, 12, and 13 received by the section, but the signature thereof does not tally with their names. And neither AD card nor unserved notice in respect of notice upon respondent number 11 has been received by the section. So the learned counsel for the petitioner is directed to take fresh step upon respondent number 10, 12, and 13 by registered post with AD and also by usual process within a week from today. Then SSL list the matter after 4 weeks awaiting service report upon respondent number 11, 12, and 13. 10, 11, 12, and 13.
Lordship, interim order is that.
Interim order passed earlier shall continue. Why? Notice is yet to be served.
4 weeks. Lordship has already granted 4 weeks time.
On 2nd June.
Public.
28.
Lord, I'm appearing on behalf of respondent number 1.
Lordship, I am appearing for the petitioners. Petitioner, according to the service office note dated 27/2/2025, this service has been completed on all the respondents.
How many respondents are there?
5.
5 respondents.
5. Then you are appearing?
1.
1.
1.
1.
One is the principal and others are pro forma respondents.
So we'll list the matter for admission then.
My lord.
But Mr. Your good name, please.
My name is Shauman Chaudhary.
Shauman Chaudhary, learned counsel for the petitioner, and Mr.
A.K. Rai.
A.K. Rai, learned counsel for the respondent number 1. Office note dated 27/2/2025 indicates that service upon respondent number 2, 3, 4, and 5 completed, but they remain unrepresented today. Since service has already been completed, SSL list the matter after vacation for admission.
Lordship, on a date be fixed.
28 April.
But can it be in the first week of May?
Okay.
On 6th.
And interim may continue.
Interim order passed earlier shall continue.
29.
In this case, we are appealing for the respondents. I am appealing for the respondents. And the service is completed so far. We will file our objection to the CRP lordship.
Gotcha. Both the parties are duly represented by their engaged counsel. It is submitted at the bar that service has already been completed and the respondent also filed objection and the matter is ready for admission hearing. Accordingly, it is provided that SSL is the matter for admission hearing after vacation. After vacation.
After vacation, lordship.
Lordship, the next date in the lower court is on 7/4, your lordship. There is no interim, your lordship. In the last order, it is reflected that after appearance of respondent, interim will be maybe considered.
Lordship, there is a delay of actually 1 day. Only there is a. He took objection before the trial court. That was rejected in the file misappeal. That was also rejected. Now he is challenging that part. He has come up before this court. So just to place the true facts before the court, just that affidavit of the opposition is required to be filed. What is the use?
The respondent
The delay because court has.
Okay, we'll fix it that before the date fixed by the trial court.
Lordship.
Okay.
6 for lordship. 6 of April, yes, lordship. 6 of April, I am here. 4th April. Yes, Lord, I am here. I am ready to do that. No, yes.
Item 30.
Obliged.
May I please your lordship? Lordship, the office note shows that AD card has not received back, lordship. And the service report has been awaited, lordship.
Mr. Mazumdar, you are for?
I'm for the claimant, lordship.
And you?
I'm for respondent 20.
20. How many respondents are there? Pardon?
4.
Let this matter fix before the Lozima court for drawing presumption.
Third, miss, your good name, please.
A. Sharma on behalf of B. Chakrabarti.
A. Sharma, learned counsel appearing on behalf of
B. Chakrabarti, lordship.
C. Chakraborty, learned
CGC, lordship.
CGC for the applicants.
Applicants.
Then Mr. Majumdar for respondent number
1, lordship, claimant.
respondent number 1. And Mr.
A. Burwa.
A. Borua for respondent number 2 and 3. Office note dated 21/3/2025 indicates that AD card in respect of the summon issued to the respondent number 4 is awaited. The learned counsel for the petitioner submits that the matter may be referred to laws in my court. Accordingly, it is provided that RSSL lists this matter before the laws in my court.
Highly obliged.
Lordship. 31.
So, madam, the amount is deposited.
Yes. No, their petition is different, lordship. Matthias something.
Lordship, they have deposited.
So this interlocutory application is for what purpose?
Lordship, we have filed this for releasing of the 70% of the awarded amount that is disposed and directed the court to deposit 50% of the awarded amount. Accordingly, they have deposited.
No, we have deposited 50% as per
50%.
last order, lordship. It was deposited on 23/2025.
So there is no prayer for allowing you to withdraw the amount.
No, Lordship.
No.
We have not filed any. Lordship, that order may be passed in MSC. In MSC, Lordship, allow me to withdraw the amount. Lordship.
Lordship, they have to file, I think. They have.
Or Mr. A.T. Sarkar, learned counsel for the applicant, and Ms. R.D. Mazumdar for the opposite party. Ms. Mazumdar submits that pursuant to order of this court dated 2025. The opposite party has deposited a sum of deposited 50% of the awarded amount before the registry of this court.
We deposited on 20/3/2025.
20?
20 March.
28th of March 2025. and the said amount was deposited on 28 March 2025. And since the pair made in this interlocutory application is complied with this IA stands closed. In MSc appeal, that what is this?
Lordship, LCR not yet
received.
received, so Lordship, reminder will
Direction.
go. Yes, Lordship, because it is from Kamrup itself.
Okay. Or Mr. A.D. Sarkar, learned counsel for the appellant and Madam Majumdar for the respondent. Okay.
I am for the respondent, Lordship.
Okay. Oh, yes. Madam R.D. Majumdar for appellant and Mr. Sarkar for respondent.
Respondent number 1.
Office note. Dated 20th-2025 indicates that LCR has not been received.
First reminder was sent, Lordship, on 5/2/25.
So, recessal is a reminder to the learned trial court for transmitting the record without learned tribunal for transmitting the record without further delay. And in respect of service upon respondent number 2 and 3,
Has not been received back yet. Lordship, it can be in fact deemed served also because they won't be necessary. This is on quantum only, the appeal.
quantum.
Yes,
Okay.
they can be deemed served because we had taken steps by
20th February 2025 indicates that AD card in respect of service of notice upon respondent number 2 and 3 has not yet been received. Ms. Majumdar, learned counsel for the appellant, submits that respondent number 2 and 3 are not necessary party in this appeal. As the as in the appeal only quantum is being challenged. And as such, their name may be struck off from the area of this appeal. Accordingly, at the cost and risks of the appellant,
I
the
said,
name of-
Lordship, ki they may be deemed served.
No, AD card not returned. Name of respondent number 2 and 3 be struck off from the area of this appeal. Recessal lists the matter for hearing immediately after receiving the record from the learned tribunal.
Highly obliged.
32.
Lordship, I am appearing for opposite party number 2. Lordship, we have filed written objection in the IA, but my senior is out of station. So Lordship may kindly take this matter after Bihu vacation.
Heard, Miss?
B dash
Learned counsel for the
petitioner.
petitioner. Learned counsel for the applicant. And Mr.
You wrong P.
Noor Rahman, learned counsel appearing on behalf of Mr.
You wrong P. Wrong P. You wrong P. On behalf of B. Borua.
I'm appearing I'm appearing for opposite party 1.
You are for the 2.
Yes, Lordship.
For respondent opposite party number 1 and Mr. Dotto S. Dotto for respondent opposite party number 2. The learned counsel for the opposite party number 1 submits that conducting counsel Mr.
B. Borua.
is out of station. And as such, the matter may be listed after
Bihu vacation.
okay, after vacation.
Obliged.
33. May I please, sir? Lordship, as per the office note dated 24/3/2025, the process server has found that the house was locked and the sole respondent has gone for medical treatment in Chennai. So I seek your Lordship guidance now if we can take the fresh steps And in addition, a WhatsApp service may be affected. This is a case I'm challenging the decree of divorce.
Trial court, Lordship. Lordship, your Lordship was pleased to pass an order directing me to allow appear before the learned trial court, Lordship. That order, your Lordship may kindly find at least 15. And the relevant para starts page 16, para 4 and 5, Lordship.
Why you could not appear?
Yes, Lordship, I have stated my ground, page 4, para 3, Lordship.
Pardon?
Page 4, para 3. Small paragraph, Lordship.
Heard me, sir. M. I. Hussain, learned counsel for the applicant. This interlocutory application is prepared by the applicant, namely Amit Basumatari, for extension of the period to appear before the learned trial court. Mr. Hawk submits that. No, Mr. Hussain submits that. This court by order dated
Is 15, Lordship.
order dated 28/1/2025 was placed to direct the applicant to appear before the learned trial court on or before 13/2/2025 and to apply for regular bail. But the applicant is a daily wage earner and he could not manage the amount which is to be deposited before the court. Bond amount which is to be deposited before the court. And as such, he could not appear before the learned trial court within the stipulated period. And therefore, Mr. Hussain contented to extend the same by 1 week,
10 days, Lordship, kindly.
10 days. Mr. Kosik, learned counsel for the learned additional PP, submits that he has no objection. No. In the event of extension of the period to appear before the learned trial court. Further, taking note of the submission of learned advocates of both the parties, the period to appear before the learned trial court by the applicant is then extended up to in terms of this IA stands closed.
Deeply obliged, Lordship.
35.
May I please, Lordship, this is the first time listed. Well, there is a only 51 days. Delay of 51 days for preparing the appeal. Maybe notice, maybe.
Heard Mr. Arsipal, learned counsel for the applicant. This interlocutory application is prepared by the applicant for condonation of delay under Section 5 of the Limitation Act for condonation of delay of 51 days in preparing connected appeal against the judgment and award dated 7/10/2024 passed by the learned member Motor Accident Claim Tribunal, Nagaon in MSC case number 268 of 2022. Where is the petition? In the documents placed on record, let notice be issued to the respondent.
So both ways are filed. Both ways are take the step.
Pardon?
Registered with AD and as usual process.
Registered person AD.
AD and usual process.
Step be taken upon the respondents by registered post with AD and also by usual process with List the matter after 4 weeks.
My lord, next is my lord 38 days.
Ten.
36.
36. Same.
My lord, there is a delay of my lord 38 days. My lord, another case is there, my lord, supplementary, same. My lord, kindly.
What is the number?
My lord, 48, item number 48.
48.
There is a my lord, only 6 days delay.
Okay, we will issue notice.
Item 48.
48. Same, my lord.
Same.
The company is different. Much of it.
37. With due apology, Lordship, item 34. One line may be needed, Lordship. Regarding other conditions, the earlier order may be read together, Lordship. That line
That
Hmm.
is
may be needed.
implied, not necessary.
Regarding other conditions, Lordship.
No,
Yes.
no.
37.
May please, your lordship. My lord, there is a delay of 30 days in preferring the appeal, lordship.
Part means I am Chaudhary, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred for condonation of delay of 30 days in preferring MSc appeal. Connected MSc appeal against the judgment and award dated 4/11/2024. First by the learned member, MSCT. Motor accident claim tribunal, Nagaon in MSc case number 74 of 2021. Where is the application and the documents lesson record? Issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. This after 4 weeks.
First of all,
38.
May I please your lordship, there has been a delay of 133 days
1,
against the judgment on order
130,
133 days.
133. Third miss your good name.
You Roy.
Your Roy learned counsel for the FLN. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant, namely National Insurance Company Limited, for condonation of delay of 133 days in filing connected appeal against the judgment and award dated 29/6/2024, passed in MSc case number 146 of 2016 by the learned member MSCT, Motor Accident Claim Tribunal, Dhubri. Where is the application and the documents placed on record? Let notice be issued to the
Your
respondents
lordship,
return
notice may issue.
4 weeks, step be taken by registered post with AD and also by usual process within a week today.
Much obliged.
39.
May it please your lordship.
158.
Abora.
Okay. After 4 weeks.
Notice
Pardon?
whether the notice is issued.
Yes, yes.
Okay.
Item 40.
Much obliged.
May it please your lordship, we have filed an IAF for the delay condemnation of 240 days, lordship.
Or
240 days started. We have started from the court file.
Part, Mr. Your good name?
M. Ahmed.
Learned counsel for the applicant. This application under Order 41 Rule 3A of the Code of Civil Procedure is preferred by the applicant for condonation of delay of 240 days in respect of filing the connected regular first appeal.
Notice may be issued at this stage.
Where is the application and the documents placed on record? And madam, you are appearing?
Yes, 5 and 6.
It's open for respondent number 5 and 6. Let notice be issued to the respondents, returnable in 4 weeks by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 5 and 6 since they are represented by Ms. Kokon, learned standing counsel. However, Extra requisite copy of the petition be furnished to her during the course of the day. This is the matter after 4 weeks.
Obliged.
Timing item 1.
Unit perhaps receive a instruction.
Lordship, already financial sanction has been accorded, Lordship, but FOC yet to be received, Lordship, from the GAD department. Let it be, Lordship, another date. It's because of there are two and three, some couple of days left in March. That's why I have instructed from the DC of Kokrajhar that matter may be adjourned for 1 week so that they can properly communicate it with the GAD department. Only for FOCs remain, Lordship.
FOC means?
Fixation of ceiling,
The
Lordship.
ceiling has
Ceiling.
not been received.
It is a procedure, Lordship, one after
That's
another.
alright. Are you supposed to receive before this 31st of March?
Lordship, suppose to presume before this month, FOC may be released from the GAD department.
No, maybe it would be, but this will not do. Mr. Gogoi, you obtain concrete instruction.
The instruction is complete, Lordship. Already financial sanction has been accorded.
No, that's all right,
FOC,
but
FOC final releasing
this
matter
matter
is
is
upon the
pending
GAD
before
department.
Mr. Gogoi, more than 6 months, this matter is pending before this.
Lordship. They have written to me.
When they are supposed to receive the FOC? Mr. Soliha, yes. From where it will be received?
GAD department.
GAD.
Lordship.
Is there any standing counsel for GAD?
Yes, Lordship. Yes, Lordship.
Afukon?
Yes.
Can you inform me?
Yes. I can.
Okay. Can I fix the matter tomorrow? Will you please ask Mr. Fukon to
Lordship.
as secretary learned advocate to both the parties, also shall list the matter tomorrow. So as to enable Mr. Gogoi to obtain instruction from the GAD department.
I am not competent to.
May not be, but you have to.
Lordship.
And you ask Mr. Fukon to remain present tomorrow.
Lordship.
Timing item 41. Timing item 41. Timing item 8.
May please, Your Lord. Sorry, Lordship, I cannot on time, Lordship.
Sorry, my lord.
Okay.
My lord, in this case, I have received certain instruction today morning, my lord. If my lord allow me one more week time, I will file the affidavit. Otherwise, my lord, I have to rely upon the affidavit filed by the my lord, college authority. And in addition to that, I will make some points, my lord. If my lord give me one week more time, my lord, I will file affidavit because certain instruction has been received today morning only, my lord.
Heard Mr. Fukon, learned counsel for the petitioner, and also heard Mr. Das, learned standing counsel for
Higher
the
Education
higher education department. Then Mr. Upaidhyay for respondent number TN4. Mr. Das, learned standing counsel for the respondent authority submits that he has received instruction today morning. And he needs 1 week time to bring the said instruction on record by filing an affidavit. There is accordingly allowed. Or SSL is the matter on. Right, covered.
Obliged.
Timing item 9.
Lordship, in item number 9, Lordship, there was a proposal sent to the finance department on 7th of March. Lordship, I have received the instruction, Lordship, they are seeking another 10 days time to process the claim as the come to bring the proposal to its logical conclusion, Lordship. So if 10 days time will be granted, Lordship, I will be able to produce an
10
appropriate.
days time.
Yes, Lordship.
Okay. all right.
Before the you.
Kindly see their attitude, my lord. After 10, my lord, 10-3, my lord. Similar instruction has been produced before your lordship by the learned council of the education. my lord.
Ultimately, proposal is in the finance department. Let the
Yes.
Lordship, yes, we have received,
Instruction.
Lordship, that we are not aware of, the Lordship. We are aware that a file was endorsed. Now it's with us, Lordship. We'll 10 days.
Fixed time for my lord.
Heard Mr. Atia, learned counsel for the petitioner, and Mr. Sisti, who responded in elementary education department, and also heard Mr. A. Soliha, learned standing counsel for the finance department. Mr. Soliha submits that the finance department has already received the proposal, and to bring it the same to the logical conclusion, at least 10 days time is required for the finance department. And accordingly, contented to list the matter after 10 days. There is allowed place to list the matter on. 10th of April.
10th April, Lord.
Item 47.
May it please your lordship. Lordship, under compelling circumstances, this IA has been filed, your lordship. This, the suit land, your lordship, is a matter of, is a matter in the connected CRP, which is pending for final hearing, your lordship. But the government is also a party to that case. But during the pendency day before yesterday, they have served me a notice, which I have annexed at page number 8, saying that they are going to carry out the eviction on the land, your lordship, which is the subject matter of dispute, your lordship. Tomorrow they are going to carry out, and this notice dated 19th was served on Monday, your lordship.
So this notice was issued pursuant to the direction issued in WPC
Lordship.
number 1052 of 2018.
Lordship.
There is a WPC, your lordship. Actually, what happened? These petitioners, they are residing over a plot of land for many generations. Now, in the year 2018, they issued a eviction notice saying that they are going to evict the petitioner from certain portion of their homeland, saying that it also in the government land, your lordship. So at that time, we approached the Honorable High Court, your lordship. The Honorable High Court said that before carrying out any eviction, you will first have to demarcate the boundary, let them know what are the area you are going to demarcate, then you can initiate the process. Thereafter, they did nothing, your lordship. In the meantime, the petitioner has filed a title suit before the learned court below, your lordship, claiming possessory right over the suit land along with his other lands, which are patta land, your lordship. And this the Honorable learned court below, they have also filed an application under Order 39, Rule 1 and 2. The other side, the government has filed the response to the application under Order 9, Rule 1 and 2. Both the parties were heard, and ultimately the learned court below, trial court, has passed an injunction order restraining them not to carry out eviction till the disposal of the suit. Now, against that, they have preferred an appeal before the learned additional district judge. The learned additional district judge found that the order passed by the learned trial court below, there is no any perversity, nothing. But however, he was of the view that during the pendency of the appeal, they have demarcated the boundary, and therefore the interim order need not be continued anymore, and therefore he set aside the interim order, your lordship, against which we have preferred a CRP before this honorable court, and it is now at the final stage of hearing.
That's all right. If they have issued this notice pursuant to the order passed by this court in WPC number 1052 of 2018.
No, there is as such no order.
Will grant any stay.
Lords.
No, if
Can
stay,
the trial court or the first appellate court can grant stay?
that is there, the WPC does not say that you should carry out eviction or that you must carry out eviction. Only given a condition. I'll take
They
a
have
lordship.
carried out the demarcation process.
No, lordship, that is correct. But the fact of the matter is that I have filed a title suit. In that case, there is an injunction order operating. An injunction order was given. Lordship will kind of peruse that injunction order. Trial court has given a reasoned order, your
No,
lordship.
Mr. Loskor, you tell me, can the trial court grant injunction against the order of the High Court?
No, Lordship.
No, against the order of the High Court, the trial court has not granted any injunction. The trial court has granted
High
injunction
Court
for
has directed the respondent authorities to demarcate the boundary. And accordingly, they have demarcated the boundary. Now they are to carry out the eviction process.
now, lordship, the trial court has not granted interim stay against the order. In following the High Court's order only, the trial court has granted the stay. Following the High Court's order only, the trial court has granted the stay.
Following the
Order of the High Court only, your lordship.
No.
Yes, I will take your lordship to the order of the learned trial court.
Yeah, several eviction notice was issued, Lordship.
No, in between.
Several eviction notice were issued earlier, Lordship. Thereafter, they came to this High Court.
Only after receiving the
preferring the WPC, Lordship. And it is a khas government land, Lordship.
Only after receiving the
The
first
government
notice,
then-
we have approached the High Court, your lordship, by filing a writ petition. We have been in for centuries. We are there. Suddenly, they are saying that I have my homestead land. I have my homes over the plot of land, your lordship.
Nothing else, Lordship. They have failed to establish that they have Patta land. This is their Patta land. They have failed to establish, Lordship. That's why.
paragraph 26 of judgment.
Yes.
High Court judgment, WPC.
Yes.
It's not para 26. Reverting back to the fact of the case in hand, it is already noticed that the petitioner has failed to show by any kind of document that they have any bona fide claim in any part of the land measuring 15 patha and 12 patha of the land falling under the DAG number 349 of patha number 2nd RS in village Narayanpur part 2. The revenue record go to show that the plot of land covered by DAG number 349 and patha number 2nd RS has been recorded as government land and the same is reserved for road. Notwithstanding the claim of the petitioner regarding the possession of any portion of the said plot of land, the petitioner had been found to be possession in the said plot of land without any kind of permission from the respondent authorities, and as such they cannot be termed in any other manner other than encroachment. The allegation against the petitioner are that by encroaching upon the said plot of government land reserved for road, the road which is meant for the general public to commute has been narrowed down, making it difficult for free movement of the general public who use the road for their day-to-day activities. When the public interest for restoration of the government plot of land reserved for road and for the general public is considered vis-a-vis the private interest of the petitioner, it is always the public interest which shall prevail, more particularly when the petitioner has failed to make any bona fide. In view of the discussion made above, this petition is found brief without any merit and same is liable to be dismissed. Accordingly dismissed, consequently the interim order stands vacated. In the event the respondent undertake any process of eviction to clear the encroachment plot of land measuring 15 12 covered by DAG number and patha number located in which is reserved for road, the respondent authority before carrying out such process shall ascertain and demarcate the boundaries of the said plot of land. Accordingly, Lordship, demarcation has been completed. And now, Lordship, the eviction notice it cannot be state, Lordship. The public interest is Lordship involved. And this land is Lordship government. Due to Lordship, their enforcement, Lordship, the road cannot be constructed. That construction of the road is closed.
So against a judicial decision, there cannot be any stay order.
What the learned this Honorable High Court
No,
has said
forget
that-
about learned trial court. You have Madam has already read out the judgment of the High Court.
So, Lordship, in this High Court, when we filed a writ petition, we have not come for title. We had come that they have issued the this notice without giving any definite boundary. Nothing has been given. Same is the notice here now, your lordship. They are not
So
providing any,
respondents have carried out a demarcation process, then
no boundary, nothing. If their lordship goes through the impute notice, nothing is there. Nothing is there. Where is the,
so you can challenge this notice in the writ petition.
no, because the subject matter, there is a stay against the eviction by the learned trial court below, your lordship. Against that,
Maybe
they
that
filed
was
an appeal. The
vacated,
appellate court has disturbed this injunction order, your lordship, against which we are before your lordship in the CRP, your lordship. And lordship has fixed it for final hearing. Lordship can see the last order also. They were there. They said that they need some up-to-date instruction for which hearing was not held on that day, your lordship. Lordship knows in case of injunction, the trial court is the best authority who can decide whether in a
No, 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 no. Yeah, trial court cannot decide a injunction petition violating the order.
No,
of the
it is not in violation of the court's order, your lordship. It is in consonance with the court's order. Therefore, what I want to show is the interim order passed by the learned court below, your lordship. There is absolutely no road, nothing, your lordship. Suddenly they have come up with an idea that there is a road.
Yes, madam,
Yes, Lord.
let us do one thing. We will finally hear this CRP.
Yes.
After 2 or 3 days. Till then, ask the authority not to carry out the eviction order. Eviction. We will not pass any order.
Yes, Lordship, in page number 49, Lordship, in the writ petition, in the petition, Lordship, page number 51, that the LS has tag number 349 more than 950. Firstly, runs in between the land of Plenty River towards south, meet with National Highway number 154. Lordship, the construction of road is, Lordship, all because of this, they have occupied but illegally across the land, Lordship. It is a government land, Lordship. So Lordship, no stay, Lordship may hear, well, hear the matter within 2 or 3 days, but till then, Lordship, no stay, Lordship.
Pardon?
Stay was not, Lordship.
No, we will not grant this stay.
Yes, yes,
But please don't carry out it till disposal of this CRP. We'll fix it after 2 or 3 days. We'll finally hear it on it. Till then.
Yes, sir.
But we will not pass any order.
Yes.
Staying this.
Yes.
But please don't carry out the order. Eviction order. Right?
Yes.
As agreed by learned advocates of both the parties, the SSL list this IA along with CRP number 53 of 2024 for final hearing on 1st of April. 1st of April.
Lordship, they should ensure that eviction should not be done, Lordship has said, but since there is no reflection in the order, I don't know whether.
No, Madam has assured this court.
Oblige, Lordship.
Item 41, kindly.
Lordship, I have filed that is there in the reflected 3798 of 2025 ISCB, but there is no reflected. Otherwise, it has been filed.
But it is not available in the system.
It has been there, Your Lordship. I have. Is this around IS Civil 3798 2025, Lordship. Otherwise, the order is. That is the order.
No, no, it is not available in the system.
No, it is there. I have acknowledged the receipt card. Paisa? I had 3798. Yes.
Filing number.
Not registered yet. So listed tomorrow then. Tomorrow.
As a 5 item, Your Lordship.
Pardon?
As a 5 item, Your Lordship. First top priority list. Top of the list, Your Lordship. There is an urgency, Your Lordship. I beg to.
Okay, list the matter tomorrow.
Lordship.
Along with the IA.
May I please, Lordship? Top priority list, Lordship. Otherwise, Lordship, I beg to submit here. At 2:30, I will go to Gulaghar. My hospital problem is there, personal problem. So that's why priority list.
Before that, 2:30, we will take up the matter.
Lordship,
Develop, Lordship.
I have a little submission, Lordship. Sorry, Lordship, interrupt. Lordship, item number 1, can it be fixed for day after tomorrow instead of tomorrow, Lordship? With due to the other side, concern of the other side,
Okay,
Lordship.
but he has to consent.
Lordship,
Develop, Lordship.